have Mr. Tauber. You'll have to unmute yourself, sir.
Try that again. Apologize. Thank you, Your Honor. Good morning, and may it please the court. Andrew Tauber on behalf of petitioner CSX Transportation. I intend to reserve 5 minutes of my time. Every appellate system outside Ohio to have considered the issue has concluded that federal law preempts anti-blocking statutes such as RC 5589.21. Courts across the country are unanimous that such statutes are preempted by ICTA, the FRSA, or both. Indeed, it simply does not matter whether RC 5589.21 is analyzed under ICTA or the FRSA. Either way, it is preempted. Indeed, because the law is so clear, I would like to begin, before addressing the law more specifically, by addressing two practical implications, or the practical implications of this case for both the railroads and the communities that they serve. First, I would like to reassure the court that contrary to what the state and the AG suggest, holding RC 5589.21 preempted would not result in railroads blocking crossings indefinitely and without impunity. To start, it simply wouldn't happen. Railroads make money by moving trains, not by parking them. And if block crossings did become a problem in a particular locale, the Surface Transportation Board, the STB, exercising its authority under ICTA, could take action, as it has in the past. For example, with respect to a congested corridor in the Chicago area where it took steps to address blocked crossings. Those cases were cited, those actions by the STB were cited by the Indiana Supreme Court when it held that its state's anti-blocking statute was preempted. And not only could the STB take action as it has in the past, so too could the FRA, which is currently gathering data on blocked crossings. Simply put, the federal regulators would not allow railroads to gratuitously block crossings.
Counsel,
yes.
What's the timing on a response by the Surface Transportation Board or the FRA to address a problem that presents itself repeatedly?
It's an administrative proceeding. I don't have an exact timeline, Your Honor, but it certainly can be months or a year, depending on the process and the procedures involved. Just like any administrative hearing that you would imagine, Your Honor. But in addition to the economic reality where railroads simply won't block crossings unless they have to, and the regulatory reality that federal regulators won't allow railroads to do so, I think it's very important on the practical side of things to also keep in mind why it is that Congress determined that preemption of state regulation is necessary for railroad operations, which are the quintessential form of interstate commerce. In Ohio alone, there are 5,187 miles of track and 5,000.
This is all fine, but I guess I'd like to talk a little bit about the law.
Certainly, Your Honor.
In the case. One of the things that the Attorney General says that if we accept your reading of the what they call the Termination Act, it would mean that there's no authority for the Secretary to do anything under the Railroad Safety Act. Why don't you address that?
Certainly, Your Honor. I mean, it's simply not the case. Courts have time and again held state laws that relate to safety issues preempted under ICTA, and notwithstanding that long history.
I understand that, but explain to me how your reading doesn't swallow up the entire Railroad Safety Act.
Well, certainly are. There's no reason why the two laws cannot exist simultaneously. The Attorney General takes the position that you have to choose between one or the other. Our position is that both laws exist simultaneously, and the court has to consider both. In some instances, a state law might be preempted by neither statute, In other instances, it might be preempted by one rather than the other, and yet other instances, such as here, the state regulation can be preempted by both. And Your Honor, notwithstanding the fact that courts have, as I say, repeatedly held safety statutes preempted by ICTA, such as, for example, the DC Circuit holding that the Delaware idling statute was preempted by ICTA, notwithstanding the health motivations for that, the FRA has continued to issue workplace safety regulations and other regulations regarding the actual operation of trains without.
What about you? Just help me with your argument. I understand other cases courts have decided cases, but we're not bound by mistakes other courts may or may not have made. So help me understand, based on the language of the two statutes, where each applies.
Certainly. The FRSA is clearly directed at how railroads operate their trains. So it talks about the engineering of locomotives, the engineering of cars, the engineering of tracks, the safety training and all that goes to the day-to-day question of how do trains operate, how are trains operated by railroads. The ICTA, by contrast, goes to the railroad's right to operate trains on tracks and its obligation to provide services to customers as common carriers. And I think it's important to note that ICTA imposes an obligation on CSX, like other railroads, to provide reasonably requested services such as those requested at the Honda plant. And so when we're talking about the right to operate on tracks where the STB has approved the usage of the tracks, ICTA is the starting point. When we're talking about how does the train actually operate, what type of engine does it have, what type of safety devices on the trains, then the FRSA is the starting point for one's discussion. And there's some places where FRSA alone will speak to an issue, other situations where ICTA alone will speak to the issue, yet other issues which both statutes speak to. And there's absolutely no reason to feel the need to choose between the two. I would point this court to the decision of the Supreme Court of the state of Washington that we cite in our briefs. There, the court analyzed that state's anti-blocking statute under both federal statutes and concluded that it was preempted by both. Or I would point the court to the comparatively recent decision out of Oklahoma, where the federal district court found that that state's anti-blocking statute was preempted by ICTA. And there it said, addressing specifically the argument that the AG has raised here, that these two statutes are not mutually exclusive. And it didn't then reach the FRSA argument simply because it already found the statute preempted under ICTA and found no need to do so. But again, these statutes are overlapping and they have existed in harmony with each other now for decades, and there has been no parade of horribles that one sees from the unanimous set of court decisions holding statutes like this to be preempted under ICTA. It's not as if in the states where the anti-blocking statutes have been struck down under ICTA that suddenly there's a free-for-all. It's not the situation that the FRA has found it impossible to continue regulating railroad safety. The statutes exist harmoniously and the two federal regulators work harmoniously, and the mere fact that there is overlap at the margins in certain cases shouldn't be a cause for concern. And if I can turn then to ICTA in the first instance, Your Honor, in Girard, this court recognized that ICTA grants the STB exclusive jurisdiction over the operation of industrial and switching tracts, and categorically preempts state or local regulation of matters directly regulated by the STB, such as the operation of rail lines. By its express terms, RC 5589.21 regulates trains that are, I'm quoting now, engaged in switching and loading operations. So on its face, RC 5589.21 goes to the heart of what ICTA is designed, ICTA addresses and prevents, namely states interfering with the ability of railroads to operate on rail lines that the STB has authorized those railroads to use. And moreover, yes,
Isn't the state statute a safety statute?
it addresses the legislators announced its purpose of facilitating the movement of vehicles across railroad tracks. So it's as I think it was the court in Oklahoma or Washington says, it addresses local safety, not railroad safety as such.
So would we need to look then, rather than a categorical preemption, at an as applied? And if that's the case, doesn't it need to go back to the trial court, since the trial court made sweeping legal generalizations when it issued its decision?
Well, two things to that, Your Honor. I wish to remind the court that the trial court issued its decision on both bases. It found both ICTA preemption, which addressed primarily, but it also found that the statute was preempted by the FRSA. So the trial court has already found that this statute is preempted by the FRSA. The intermediate appellate court, for whatever reason, decided not to address the FRSA. But as to categorical versus implied preemption, Your Honor, every court, literally every single court without exception that has looked at anti-blocking statutes under ICTA has concluded that they are categorically preempted, and one doesn't even need to engage in an as-applied analysis, precisely because anti-blocking statutes go to the heart of railroad operations. Namely, can a railroad conduct switching operations at an industrial customer?
Except the railroad here, so the problem seems to be that it's spending an hour loading and unloading goods at the Honda plant. And I think it's a little different from switching operations.
That is switching operations, Your Honor. The reason it is there for an hour is because it is removing cars from the train to leave at the plant so that the plant can then take the contents of those cars and use it in the process, and then reassemble the train, picking up cars that had been left there previously and moving on. That is switching. And there is simply no way that one can conduct switching activities of that sort within 5 minutes. It's impossible to do. And if CSX or other railroads were unable to engage in the switching operations that they're obligated to provide under ICTA as common carriers, it'd be prevented from using their rail lines as permitted by the STB, and that is why they are categorically preempted, such statutes.
So why can't they all live in harmony? As Justice Brunner just said, there is a safety provision in the federal statutes that allows, when there are local conditions of safety, to allow locales to write statutes to protect those interests. So when you're blocking the train track and you say it's switching, why isn't that just not your defense? The state has declared a law that says this is all for safety purposes, allowing emergency vehicles to conduct their business. Why isn't that just not a defense? You get a ticket, you come in and say, we were at the Honda plant switching. Here's my proof of switching. Why don't they all work in harmony?
But first of all, there's absolutely no dispute that that's what was going on here, Your Honor. And that is our defense. We've been cited 5 times and we are defending a criminal case. That's how we are before Your Honors. That's exactly what we did. We interposed.
But what you're asking for is us to say, to declare Ohio law preempted by the federal statute, even though the federal statutes give local jurisdictions some group of rights when it comes to safety issues to adopt legislation.
But Congress very, very narrowly constrained the state's ability to do so. First of all, a state may adopt or enforce a safety regulation related to railroad safety only if the FRA has not already adopted regulations covering the subject matter. And here, as we argue, and as every court to have considered the issue has concluded, the FRA has adopted regulations covering the subject of trains moving through crossings, or alternatively, as the AG would like to have it, the issue of trains stopped in crossings.
So what regulations have to deal with trains stopped at crossings?
There are 2, Your Honor. There is first the air brake testing regulations, which compel the railroad to remain stopped after engaging in switching operations until such time as it has completed mandatory air brake testing. That itself requires stoppage of a certain amount of time. Remember, these trains are 1 to 2 miles long
It doesn't
typically.
require stoppage in a particular place, though. It doesn't
Yeah,
require,
it-
it doesn't require stoppage in front of at a crossing.
I mean, not inherent.
That seems a pretty indirect regulation to say that the secretary is regulated directly in this area when the only regulation you can point to is something that deals with trains starting.
No, Your Honor. Well, first of all, it's not the only regulation we point to. We also point to
What's the other one?
the speed regulation, Your Honor. So if a train is compelled to clear a crossing within 5 minutes, it must move at a certain speed given its length. There's a mathematical relationship between the length of the train and how fast it must move in order to clear that crossing within 5 minutes.
Now, do you think that's realistic? Let's be honest. If your train is moving and it's not completely stopped, you really think that someone's going to cite you because you're going through a crossing at a particular speed based on regulation for that crossing? I mean, what we're really talking about is your train is stopping and you're not going anywhere. It's not about whether you're still moving at a slower rate of speed.
No, the statute is clear, Your Honor. If our train stops for any reason within our control and explicitly, including for reasons of switching, then we must clear the crossing within 5 minutes, an absolute requirement that it must be cleared within 5 minutes. So
But we're talking about two different things. So let's parse that out. Stopping at the Honda plant, switching out cars. I'll use your terms. You've now crossed the tracks and everyone's waiting for you to clear. You take an hour or two to unload, switch. That's different than what you just said. In response to Justice DeWine, he said, what's the second statute? And what you say is, we would violate the statute if our train is moving at a slow speed in order to adhere to the regulations of speed for certain particular crossings. But I don't read the Ohio statute as saying you can be cited if you're moving.
no,
It's
but
literally if you're stopped.
but no, Your Honor, the trigger is stopping. Once we've stopped, the law is triggered. And then we must clear the crossing within 5 minutes. So it's not that we would be cited subsequently for moving at a slow pace. It's rather we would be cited for not having cleared the crossing within the allotted 5 minutes. And in order to do that, to clear the crossing within 5 minutes, we might very well have to increase the rate of speed to a point where it would violate the speed regulations imposed by the FRA. And let me, I want to go back to the air brake testing regulations, Your Honor, because I mean, every court to look at this has agreed that the air brake testing regulations govern when a train must remain stopped. The FRA insists that trains remain stopped until certain tests have been conducted after switching. And
That's something different, right? You're not going to, there's not a time regulation that every 8 hours the train stops and you check your air brakes. It's when you have originated a stop to switch offload, and then you're getting ready to start again, you must test the air brakes to ensure that the brakes are bled and that they will operate safely.
correct, Your Honor. But that takes time.
Okay, that takes time. So what we're really back to is air brake testing is after you have originated a stop, like at the Honda plant. It's not as you're moving through the crossing guards. Going back to Chief Justice O'Connor's question, let's be honest, railway travel has occurred since the mid-1820s. Federal government has taken over railway travel since 1917, 1920. Yet to date, there's no statute that protects local communities for what we're really talking about, is the fact that if you block these rail crossings, and perhaps in a community, those are their only pathways to get across for emergency vehicles. So local communities are just at the whim of you and profit.
Your Honor, that's certainly not true. Absolutely not true. First of all, the reality on the ground is there are close by crossings so that if one crossing is blocked, the nearby crossing can be accessed. So if in an extreme case, an emergency vehicle had to get from one side of the Bear Swamp Road crossing to the other, and the crossing was blocked, it would take 7 minutes to get to the other side using the nearest crossing. If it started originally from the dispatch point, it's an only additional 4 minutes. So there are alternatives. Moreover, there are regulatory.
Counsel,
Yes, Your Honor.
you've used your time, but I want to ask one question.
Yes.
Is there communication between the railroad and the community when something like this is going to happen so that safety forces, et cetera, are on notice?
Yes, Your Honor. We proactively coordinate with the Sheriff's Department so they know our general operations. When it becomes clear to us that a planned blockage is going to last longer than anticipated, we immediately communicate that to the Sheriff's Department. The Sheriff's Department has an app that allows citizens of the area to know when blockages are anticipated or are occurring, so citizens do know. And more, I also want to point out, in addition to our proactive coordination with the Sheriff's Department, we also have spent money to install supplemental air compressors at the nearby crossings so that we can load the air the air pressure quicker in the trains so that we can minimize the duration of the crossings. We take the community's concerns quite seriously, to say nothing of the fact. Thank you.
Thank you. Your time is up. We will go now, I think, first to, is it Ms. Hobbs will argue first?
Yes, thank you, Chief Justice, and may it please the court. My name is Samantha Hobbs, and I'm an assistant Union County prosecutor here on behalf of the state of Ohio. I'm joined today by my colleague from the Attorney General's office, Mr. Zachary Keller, with whom I hope to split about half of my time today. Your Honors, I'd first like to start by addressing Chief Justice's question about the length of time that it takes the FRA to respond. I don't have a specific length of time, but I can say, admittedly outside the record, because we're at the motion to dismiss phase, that since September of 2019, the Union County Sheriff's Department alone, not every agency in Union County, specifically the Sheriff's Department, has made 198 complaints to the FRA about the blocked crossings, and nothing has been done. So it seems that the answer is at least a year and a half before the FRA will take action when there is a consistently blocked crossing.
Counsel, what's the alternative? In this situation, what's the alternative? What can Honda and CSX, what can they do?
Chief Justice, I'm not sure. I don't know enough about the way that the railroad functions to know what the other options are, whether that's, I know other places, there have been solutions for building bridges or taking more proactive steps. I know Mr. Tauber related to the court that CSX is very proactive and the Sheriff's Department is always aware of when the blockings are going to happen, but that has not been the experience related to me, that a lot of times they don't know that this.
The counselor, to piggyback on that then, so we don't know if there's a solution that could eradicate the problem of the crossings for safety reasons and other reasons for the people in the community, and yet still allow businesses such as Honda to, continue to function. I would venture to say that the continued work in that community is also important.
Yes, that's true. I don't know the exact solution, but I know that the solution cannot be to just find the statute preempted and allow the train to stop as long as it wanted.
Well, counsel, isn't the solution what Mr. Tauber suggested, or didn't suggest, but stated, there's an alternative route. And vehicles such as safety vehicles, if dispatched and being apprised of the blockage at this particular crossing, can use an alternate route in order to accomplish their duties. And citizens the same way. That I mean, if the train was blocking all egress and ingress on the roads of the community, that's one thing. But what I'm hearing is there's alternates that are reasonably available. Is that, do you find that to be the case?
Certainly when law enforcement or police and fire have advanced notice, they could take an alternate route, but it's the problem of when they don't have notice and they get there and they find that the train is blocked and they have to take another route. But plus, the statute applies to the entire state. So although in Union County at the specific Bear Swamp crossing, there may be an alternative route when law enforcement knows about it, I don't know that that is the case for all of the rural communities throughout the state of Ohio who have been affected by this issue. And to Mr. Tauber's point that because of business, they wouldn't want to stop for a very long time. If the court looks at the legislative history and the discussions that took place when the legislature was enacting 5589.21, there was large discussion about a train up in the northern part of the state that stopped and blocked a crossing for 2 full days. So the state's not trying to be alarmist here. And it's not to suggest that they would stop for 2 full days every single time if the court preempts the statute, but blocked crossings are a problem and they present an issue and they shouldn't be preempted for a number of reasons.
So out at the Honda plant, is there a spur or a deadline where the cars can be delivered and the empty ones picked up? Have you ever been out there?
I have not been out there, Your Honor. I have been in that direction, but I've never taken a look at the track specifically. I could certainly speak to someone and brief that further for the court.
No,
Okay.
no, I just want to know if there are spurs or deadlines out there to facilitate the movement and the unloading.
Yeah, I'm not exactly sure what the precise setup of the tracks is out there. But even still, we would ask the court to find that the statute is not preempted. The first reason for that is the presumption against preemption. I think presumption is probably a bit of a strong word, but the courts have consistently held, including the United States Supreme Court, that when police powers are involved, the court should be hesitant before finding those powers preempted. Here,
Counsel, let me ask you this. These penalties involved with the anti-blocking statutes, they're supposed to have an effect. They're supposed to deter behavior. So if CSX is fined, but they can go into court and present a defense because they're obligated to do what they're doing, how does that resolve the issue? How does the utility of this law, how does it come to fruition if they have a complete defense because they're obligated to do what they're doing?
well, if they have a complete defense, I would say it still has some deterrent effect because they have to come into court and they have to present the defense, but it also provides penalties for those situations wherein they don't have a complete defense and there's not a good valid reason for them to be stopped. Furthermore, the statute 5589.21 doesn't allow for just any operation and anything outside of their control to be a complete defense. There is a lot of conduct that's covered by 5589.21. But even if there's not utility, the statute still is not preempted by the federal law. Under the Federal Rail Safety Act, it's clear in that express preemption that we fall into the first safe harbor here. This is a safety statute. It's related to rail safety. There are safety concerns caused by the train, and the federal government has failed to pass any regulation about the blocked crossings. I know that Mr. Tauber had 2 main arguments and pointed to 2 federal regulations, that being the air brake testing and the speed regulation. As to the air brake testing, there's nothing, as the court pointed out, that requires them to stop in any certain specific place. So there's nothing on the record to suggest that it's impossible for them to comply with both the air brake testing rules and 5589.21. Now, as to the speed regulation, that is an argument that has been made in many courts, and Mr. Tauber himself quoted the line originating out of City of Plymouth in the CSX case that I think has been misused by a lot of courts because it talks about the fact that speed necessarily has a mathematical calculation. And many courts in evaluating anti-blocking statutes have cited that specific quote from that case, but it's important to look at the origination of that quote, because in that case, the statute was not just the anti-blocking like it is in this case. It also had language that said if the court is traveling over 10 miles an hour, it can only block a crossing for 7 minutes. Clearly, in that case, there is a speed component. Clearly, in that case, the statute would be preempted because there is a speed regulation. But in this case, there is not that speed component. There is only the anti-blocking statute that a train cannot park on our roadway and block Ohioans' access to the roads and to the emergency services. And I see I'm at more than half my time, so I will ask the court to affirm the third district, and I will yield to Mr. Keller. Thank you.
Ms. Hobbs, just one question.
Sure.
Your colleague on the other side seems to really want to lean heavily on ICTA, but it seems to me that you mentioned police powers and there are safety aspects to 5589.21. Wouldn't the FRSA be the more appropriate federal statute to be looking at here?
Yes, Your Honor, we believe it would. The Supreme Court back in 1921, the United States Supreme Court in Erie Railroad, the Board of Public Utilities Commission held that there is no more obvious case of police power than grade crossings. We believe that this is a safety issue, and we would ask the court to analyze it under the FRSA. But I will yield to Mr. Keller for a more in-depth discussion should the court determine that the ICCTA is the proper remedy.
Thank you.
Mr. Keller.
Chief Justice O'Connor, and may it please the court. This is a complicated case, but I think you can reduce the core analysis down to 3 points. First, it's the Safety Act, not the Termination Act, that governs preemption for laws related to railroad safety. Second, Ohio statute is a law related to railroad safety, as the federal law is using that phrase. Third, under the Safety Act, and particularly the first safe harbor, the Secretary has not covered this area, this subject matter, because as everyone in this case seems to agree, there is no federal regulation that governs how long a parked train can block the road. So I want to touch on those 3 steps, but before I do, a few threshold points. I think we need to be careful about what analysis we're performing here. This is an express preemption case. There have been a lot of questions about the practicalities, but we're not at a dormant, we don't have a developed dormant commerce clause challenge where we're weighing the burden on the railroad versus the safety interests at stake. Those types of cases require factual records, and we don't have a developed point here. We also aren't, this is not also a conflict preemption case. So if we're worried about the relationship between air brakes and Ohio's law, I would argue there's a good argument that that's wholly beyond the railroad's control to begin with, so there might not even be a violation. But that's an analysis for a later stage in the case. Another threshold point is just a basic principle of federalism. We don't have a US Supreme Court case on point, so it is this court's job to come up with the right answer, and if reaching the right answer means splitting from non-binding authority, well, that's why we have a US Supreme Court to resolve disputes about federal law. And then I would also emphasize what I'll call the federalism canon, that when you have a traditional area of state authority, you have to come to the statutory language against that backdrop. Congress doesn't hide elephants in mouse holes, so we don't expect it to be making large changes to the federal state structure in opaque ways or unclear ways. Going to the steps, I'm not sure I'll have time to get through all of them, so I do want to direct the court to the Tyrell decision out of the Sixth Circuit, because if you're looking for a sample as to what we think this court's analysis should look like, Judge Seiler's opinion in Tyrell does a near perfect analysis of these 3 steps. The first thing we need to do is sort out the relationship between the Safety Act and the Termination Act. And the danger here is if you read that Termination Act preemption clause about rail transportation as broadly as the railroad wants you to, you are going to be swallowing massive portions, if not the whole, of the Railroad Safety Act. And we try to avoid implied repeals like that whenever possible. And it is very possible to do here. And it's by reading the Safety Act for laws related to railroad safety operates as an exception to the normally broad preemptive coverage.
So help me understand why this is a law related to railroad safety.
Absolutely, Your Honor. I think that's the second step here. And related to railroad safety is admittedly a tricky phrase, and I don't probably have a good bright line rule that's going to reach every case. But here, I think we can be comfortable that we're within the margins, because at the very least, if you look at the statutory text, it covers safety concerns that are caused or created by the railroad's operations. And we know that from the 20101 provision that is, it's a codified purpose statement, but in essence, it is a definition of railroad safety. And that says that what we're trying to get at here is safety in every area of railroad operations. So if we have a safety concern that's actually caused by the railroad, which I think no one disputes here, we are comfortably within the margins of that. I would also point out to the court, obviously we're asking the court to reach different outcomes than a lot of these cases, but a lot of cases have held that anti-blocking statutes are laws related to railroad safety. Illinois Supreme Court in the Village of Mundelein case did, and Sixth Circuit in Plymouth and the Pennsylvania Supreme Court in Krentz also analyzed these laws as laws related to railroad safety. I do want to touch on the third step, which is actually applying the Safety Act, and I'd like to focus my time on the first safe harbor. Just to reground us in the text, what we're asking there is whether the Secretary has issued prescribed regulations or issued generally applicable orders that cover the subject matter. Railroad has been unable to point to any. I know they say we could lobby or petition the federal government for a solution, but that's gets the defaults of the first safe harbor exactly backwards. Until the federal government actively steps in, it is the states that get to regulate.
Well,
and I want to,
let me ask you this. Well, I mean, maybe there's a federal policy here that they're not going to stop railroads from blocking crossings. I mean, I don't know how you would expect the federal government to write a regulation that says it's okay. So, I mean, what would a regulation you think look like that would cover this subject matter?
Sure, Your Honor. The first safe harbor does require the federal government to actually act. You can't infer that they think it's okay from silence. Now, if the federal government does make a policy decision that they think it's okay to block the roads, they could write a permissive regulation that sets either a very long time frame or says there are no limits on how long the train can block the roads. And then we might still have a debate about the second safe harbor, but I think our first safe harbor argument would be done. I see that my time's up. If I might just make a few quick points about the railroads argument.
All right, you may take a minute.
Thank you, Your Honor. 2 quick points. First, there is no limiting principle to the railroads argument. This case is not about something like, well, is 5 minutes too stringent? They're seeking to wipe states completely off the board. The second point would be that if you look at the railroads argument, they don't have a good answer for how these laws are interacting. I know for the first time today in argument, we heard this distinction. I'm not sure I understood it, but between operation and licensing, I guess, was the attempted distinction, but that has no basis in the text. What the text says is that the Safety Act covers laws related to railroad safety. And as I argued, I think we're in that pocket here. So with that said, we'd ask the court to affirm, and more specifically, we'd ask the court to hold that there is no express preemption of Ohio's law here. Thank you.
Thank you. Mr. Tober, you've used your time. You may take a minute. You'll have to turn your mic on.
Thank you, Your Honor. Addressing the last point first about the text of the statute. The text of ICTA is clear. ICTA expressly states that it preempts not only state law, but federal law. The Attorney General simply does not confront the statutory language. As for the FRSA, even if the state gets past the first hurdle on the ground that the FRA has not issued a regulation specifically covering blocked crossings, it still must satisfy each and every prong of the 3 prongs of the local safety hazard exception, and it cannot satisfy any of those prongs, let alone each of those prongs.
Isn't that an either or? The way the statute's written, either you satisfy the first safe harbor or the second one?
That may be a fair point, Your Honor, but I'd go back to the first. It's simply not the case that they satisfy the first safe harbor. The federal regulations say we must remain stopped after switching until we conduct tests. Federal law also says we must stop and switch at the Honda plant because we're a common carrier. We're obligated to stop at the plant, we're obligated to switch at the plant, and we're obligated to conduct air brake tests after we switch and before we move. Federal law requires us to stop and stay stopped until we've conducted those tests.
But there's nothing in the record that shows that federal law requires that you stop in front of a crossing. And I don't have any idea what the setup is at the Marysville plant. I don't know whether to unload or load, you have to stop in front of the crossing.
Absolutely. There is no way, there is literally no way to conduct the switching activities at the plant without blocking the crossing.
How do we know that on this motion to dismiss?
I mean, it's not disputed. You can take judicial notice of the maps of
You
the
want to go
area.
out there and take judicial notice, figure out how long the trains are and figure out where they have to stop and how it works.
Your Honor, I mean, it's not in the record because it's simply not disputed. But again, the specific facts don't matter here. We're talking under ICTA categorical preemption, in which the case law is clear that when a state attempts to regulate the use of tracks, that is categorically preempted by ICTA. Factual development simply is not necessary.
Counsel,
Yes.
it's been 100 years since Erie and police power issue.
Yeah.
And the secretary hasn't issued any regs about anti-blocking laws, and yet there's all these cases. Shouldn't we take that to mean states are okay to do anti-blocking laws?
No, quite the contrary. All these cases have held that states may not enforce
No, I'm
anti-blocking.
asking the fact the secretary hasn't issued a specific reg about the anti-blocking issue. For 100 years.
It's not, it's, well, I mean, several things, Your Honor. It's not necessary. It's the United States Supreme Court in Easterwood made clear that the question is not why has the secretary adopted a regulation, nor what the target of the regulation is. The question is, what is the effect of that regulation? Because in Easterwood, the plaintiff there argued that the secretary had not issued a regulation specifically governing speed at grade crossings. The plaintiff correctly pointed out that the speed regulations that the FRA had issued were designed to prevent derailments and were not designed to prevent collisions at grade crossings. The Supreme Court says it does not matter why the secretary adopted regulations. The fact is, in effect, they cover this subject matter because it has an effect on the same matter as the state regulation would. And so to here, the mere fact that the air brake testing regulations are not designed to address blocked crossings does not mean that they do not address blocked crossings. In fact, they compel blocked crossings by the duty to serve localities and then to conduct brake testing after switching cars at those industrial customers.
But
So
in
in response to,
the fact that, as you said earlier, the only thing that's undisputed, this is a switching issue. It's not an air brake issue. It's not a speeding issue. It's the switching that occurred at Honda that's at issue.
Yeah,
Right?
but I'm sorry, Your Honor.
Correct? That's what you said.
Well, yes, but we shouldn't be, I mean, but at the same time, I want to be clear that though this case arises from citations issued outside the Honda plant in Marysville, this is a statewide issue. Indeed, this is a statewide statute, and there are over 5,000 crossings. And so we're talking about this situation in this one locale, but it can occur elsewhere. And that underscores the fact that this is a statewide statute, underscores why the state is unable to satisfy the local hazard exception under the FRSA. It is clear from congressional legislative history, as well as the court decisions interpreting the FRSA, that a statewide rule is by definition not something addressing a local safety hazard.
so is that your strongest argument in response to Justice DeWine and Justice Fisher, that it's subsection A of 49 USC 20106, that A2, that it's the elimination or reduce any essentially a local safety or security hazard?
Yeah,
Is it that or is it B, that they've already regulated? I've heard two things from you.
I'm not going to pick between my children, Your Honor. I love them both. It is both the case that the FRA has regulated when trains must stop and remain stopped. And it is also the case that block crossings are not an essentially local hazard. They are across the country, across Ohio, across Union County. They are everywhere. They're simply not a local hazard. You know, a
Thank
local.
you.
Yeah,
Thank you,
Your Honor.
counsel. Thank you. We will take the matter under advisement and you'll be notified of our decision. Thank you all.
Thank you, Your Honor.
Our next case is 2020-0700, the state of Ohio versus PJF. For the appellant, Mr. Miller.
Good morning. May it please the court, Chief Justice O'Connor. My name is Mark Miller. I represent the appellant, PJF, in this case. I please request 3 minutes for rebuttal. There's just one assignment of error proposition of law for this court's review involving a felony non-support or child support case dealing with sealing of a record. Here we believe the appellant, PJF, was eligible and became eligible because he was finally discharged from his conviction when the trial court discharged him early from his community control and the statutory waiting period elapsed. Just a couple key facts in this case. This is an F5 felony of the 5th degree. The case went to trial. Jury trial convicted the appellant. At sentencing, and this is critical, at sentencing, the trial court placed the appellant on 5 years of community control. At sentencing, the judge specifically stated on the record that she was ordering that the appellant pay all of his past due outstanding child support arrears as a condition of his community control in the amount of approximately $8,800. The trial court also incorporated its sentence into a final sentencing entry detailing the conditions of the appellant's community control. A couple years passed. There were a couple probation violations in this case, Your Honors. We recognize that. The trial court did order the appellant to serve some days in jail for failing to pay child support. However, after 2 years, the trial court decided to terminate or discharge him from community control unsuccessfully. That order, by the way, is in the record where the trial court specifically finds that she is discharging, and that's the word she uses, discharged from community control. The state never appealed that order. Years passed, past the statutory waiting period for a sealing of the record. We filed for sealing. We had a sealing of the record hearing where we made arguments. And the trial court judge, we believe, appropriately found that the appellant was eligible for sealing and that his interests were certainly not outweighed by any governmental interest. The 10th District was primarily relying on this court's decision in Aguirre. That case dealt with restitution primarily. When we are dealing with here a much more specific scenario involving child support arrears. On page 8 of our brief, we cite to at least 2 cases which have specifically distinguished between a trial court ordering all outstanding arrearages as part of community control versus arrears contained within the indictment or the criminal conduct, which would be an unconditional part of the person's sentence under 2929.18. Unfortunately, there are little cases. We try to search within the United States on this issue regarding child support specifically and sealing of the records. There are not too many cases out there. Unfortunately, the legislature has not defined final discharge for purposes of sealing. So we are left with primarily 2929.15 and 2929.18.
Mr. Miller, Do you think that it was of consequence to the trial court that she was aware that that your client now had custody of the child?
Your Honor, I don't believe at that time, are you talking about the trial court, the sealing of the record hearing, Your Honor?
Correct.
I think that may have been part of it, but primarily, I think the major part of it here was my client, PGF, was a victim of a terrible crime. He was shot multiple times. The shooter went to prison for 11 years. He had 32 surgeries. His reason for filing for the sealing of the record in this case, in this specific case, was to apply for victims of crime under the Ohio Attorney General program. You cannot apply for victims of crime if you have any felony on your record within the past 10 years, even a child support conviction. So I think the trial court weighed all those interests. The state presented no governmental interest in having the record maintained, other than they objected on the fact that he had failed to pay his so-called court-ordered restitution. But yes, my client did get custody about a year after the hearing. The child is now emancipated. She's 21. She lives with my client. So all those were factors to consider.
Mr. Miller, one last question. So there's a fine distinction between satisfaction of the requirements of a sentence constituting a final discharge and release from the requirements of the sentence as constituting a final discharge. I think what you are going to be asking us to do is to look at Aguirre and say that both of those constitute a final discharge. Am I correct?
Well, we are asking the court to distinguish Aguirre because the appellant, this is strictly a 2929.15 case where the trial court bundled together everything, including his outstanding arrears, as part of his community control, whereas Aguirre really was a restitution case under 2929.18. So we're not asking the court to necessarily overrule Aguirre. It certainly could, but we're asking the court, given the facts and circumstances of this case and a child support case, to distinguish it.
Right.
So there was, go ahead.
But my point is that he technically hasn't satisfied all the conditions of probation, but the court essentially changed its mind and said, I'm releasing you and you have no further obligation.
I understand, Your Honor. Yes, our argument is when he was discharged from his community control, given that the arrears were ordered as part of his community control, it's off the books. It doesn't mean the child support's off the books. The Child Support Enforcement Agency can still collect child support. That happens every day. The obligee, the mother, can file a motion for contempt. Our argument, he was discharged when he was released from community control. Now, if this was strictly a restitution case, however, if a trial court orders restitution, that contains no time limits. Community control is up for 5 years under 0.15. Under 0.18, there are no time restrictions for restitution unless the court modifies the amount.
Thank you.
So the authority is 2929.15. We also make a public policy argument. Of course, again, my client's interest was applying for victims of crime, but given this is a child support case, we believe a reasonable argument can be made. If you're trying to pay child support with a felony on your record, it may, not always, but may prevent someone from gaining employment or housing in those situations. So the public policy argument there is, but also
Counsel, you can say that about any felony conviction and some misdemeanor convictions.
That's very true, absolutely. And the whole point here is trying to give people second chances, and the sealing statutes, there's some case law that says the sealing statutes really should be read in a liberal way to effectuate the purpose of giving people second chances.
And maybe if he had done something to alleviate the debt that he, which was ongoing, right?
$8,800, yes, Ron.
I mean, but it was throughout his period of community control, he did not pay the arrearages, correct?
That is correct, Your Honor. Yes.
Okay. And so for whatever reason, the judge stops community control, but she never said, you don't have to pay those arrearages that I ordered.
No, she did not say that. She said he was discharged from community control. And you're right, that does not mean he does not still have to pay. I mean, in domestic court, that order was still in effect for him to pay.
In fact, it was mounting, was it not? Were there additional, fees and obligations mounting?
There probably were. That's not in the record. What's in the record is the $8,800 approximately in arrears. And you're right. Unfortunately, and he testified in his own defense about why he wasn't paying, and he was fearful that the money wasn't going to the right people and to the child. But whether it's successful completion of probation or unsuccessful under the statute, our argument is, Your Honor, when he was discharged from community control, he was discharged. And after the 3 years passed, he was eligible to have that record sealed.
Counsel, isn't the distinguishing factor between restitution and this obligation is restitution arises out of the crime for which the person was placed on community control. If someone steals something and it was not recovered, they have to pay the value of that. This obligation existed whether they were on community control or not, outside of the case, right?
That is correct. And when he was discharged from probation, again, that did not necessarily discharge him from his arrears in domestic court.
Right. Okay. So has the state ever articulated in any of its briefings what the government interest is in maintaining this conviction on the books in this particular case?
Absolutely not, because there is no interest, because there simply is no governmental interest. This is my client's only felony on his record. The child's emancipated. He took custody of the child. Child testified at the trial. Their only objection, Your Honor, was he didn't pay the court-ordered restitution. So no, to answer your question, they have not articulated that.
Mr. Miller, one last question. So I compare this case with the 10th District case of Gainey. In a restitution case, the person who doesn't, because of Aguirre, doesn't achieve a sealing of the records is able to go back and pay that restitution and then come back and apply again. In this case, we could say, yes, he could go back and pay his child support and then come back again. But if we continue in this vein, what happens where an offender would be released from community control as unsuccessful because of something that's unalterable, like a failure to report out-of-state travel or a dirty drug test? There is no way to go back and to alter those circumstances. What do we do?
Right. And this becomes a problem because, again, the legislature has not defined final discharge specifically, but Gainey, I believe, was a case involving community service. And, community service cases have not reached this court yet, but they might, regarding sealings. But typically, community service would be part of someone's probation or community control. And if it's part of their community control, again, if they are discharged before 5 years or at 5 years, they become discharged, we believe, and it's off the books. Someone may have trouble completing their community service. We don't know. They may become disabled. We don't know. The prosecutor can always go to the court and have their community service modified, possibly. But those are issues that may need to be addressed at a future date, because here, our proposition of law is rather narrow, dealing with child support cases.
What do we do with the language in Aguirre that says that final discharge means completion of all sentencing requirements? Do we have to modify that? Is that wrong? Is that incorrect?
I don't think the court has to modify it. There might have to be some clarification there. It depends whether or not the sentence, again here, arrears, the sentence is part of community control, or if the trial court judge really is imposing restitution. For example, in your case, Justice DeWine, you held in Allen a bank, or banks were considered a victim for purposes of restitution under 2929.18. That's a 0.18 case where restitution, again, there are no time limits. So it really depends on whether or not the sentencing requirement is part of community control or an unconditional part of the sentence itself under 2929.18.
So counsel, are you saying that the restitution, or not, excuse me, the payment of the arrearages is not a sentencing requirement?
It is a sentencing requirement for purposes of 2929.15 in this case.
Okay. And had he been given 6 months in jail plus the payment of your arrearages, and he was then discharged from jail, all right, are you saying that his obligation to pay then is terminated?
If there are still outstanding child support arrearages as part of the person's community control and they have not paid, they are discharged from probation. Those arrears are still on the books separately in terms of either restitution, the Child Support Enforcement Agency, the obligee. They are still out there. But for purposes of sealing of his record, we believe a discharge from community control, in this case, regardless of whether or not his child support was paid, makes him eligible for sealing. That's all we're saying. The child support, sorry.
Counsel, you're making this distinction, which I understand, between arrearages that were owed anyway, right? Versus what was put into the final judgment to pay the 8857.80, right? Why can't both apply?
I'm sorry, Your Honor, why can't both apply?
Why does that number, you're saying because he owed it beforehand and he owes it now, that it shouldn't apply to this discharge issue, right? And I'm saying, why? Why can't it, because it was put in the final judgment, why can't it apply to the discharge issue as well as still be owed before and after?
Oh, I think it can be.
Well, why, here it was included in the judgment, right?
Yes, it was, specifically, yes.
As part of the community control.
Specifically, yes.
Okay. So I'm just wondering why it can't be both?
Because under 2929.15, and it's child support case specifically, and about a dozen courts of appeals have held this, and I know those cases are not binding on this court, but if it's the total amount of arrearages, which it was in this case, in a child support case, it's viewed as a condition of community control. If the trial court judge orders him to pay just the arrears within the indictment or within the time frame of the criminal conduct, it's viewed as restitution under 2929.18, which can last. There are no time limits on that. And finally, for the record, I would note the appellant no longer owes child support. That was referenced in the 10th district opinion in this case. The parties agreed to deviate finally to zero. However, I'm not sure that really has an effect on this particular appeal. If there are no further questions.
I have one question. As it relates to this case, and maybe I missed it in the record, was this reduced to a lump sum judgment?
It was reduced to a lump sum judgment of zero.
No. At the time that the arrears were due and owing of the criminal case, at the time that it was part of community control that he has to pay on the arrears, had it already been reduced to a lump sum judgment?
I don't believe so, Your Honor. I believe that was what the Child Support Enforcement Agency presented to the court as to how much he owed at that time.
Thank you.
Thank you.
Thank you. Mr. Walton.
Thank you, Chief Justice O'Connor. May it please the court. Good morning. Your Honors, initially, I want to address another matter before I get to the merits here this morning. And the state would submit that this matter should be dismissed as improvidently allowed, as there's been a material change in circumstances since this case was accepted. In fact, since the briefing was completed in this case. This court held in State versus LaSalle that the version of the record sealing statute in effect at the time of application is what controls. And of course, the version in effect at the time of PJF's application required satisfaction of that 3-year waiting period. At the end of the session for the General Assembly, after briefing was completed in this case, they, through House Bill 1, amended the waiting period as it relates to certain felony offenses, F4s and F5s. So the waiting period now, as it had been 3 years, the waiting period as the law exists now is 1 year for felony 4 and felony 5s. And this went into effect 2 weeks ago. So because PJF was convicted of the F5, this statute could apply to him. And there's no doubt now that he has achieved a final discharge from the state's point of view, based upon that satisfaction of the judgment in domestic relations court and the zeroing out of that balance. That was done in April of 2019, actually when the appeal was pending in the 10th district. But there's no doubt now that he easily satisfies that 1 year waiting period. And if he were to file an application even today, that application would be subjected to the new law in effect. He would have to satisfy the 1 year waiting period, which he has done at this point since that was cleared in 2019. So based upon that change in circumstances, I would submit that the matter should be dismissed. But even if we get to the merits, the argument still fails.
Is the state saying it wouldn't object to him having his record sealed?
At this point, he certainly qualifies. That was the only ground that was raised by the state's objection previously, that he hadn't attained that final discharge and he hadn't satisfied that waiting period. Both of those conditions have been met at this point. And so I think these types of cases, it wasn't long ago when non-support convictions in general couldn't be sealed based upon the existence of a minor victim. 2953-36 prohibited sealing records where you had a misdemeanor of the first degree or a felony offense and the victim was a minor. And so that essentially prohibited all non-support convictions from being sealed. Within the last 5 or 6 years, that's been amended. There's a specific carve out now for non-support cases. So, the interest in maintaining the records of this particular conviction, I think, is very small from the state's point of view. And I think this is a situation where a trial court could easily find that the applicant's interest does outweigh any interest that the state could assert. But again, our only objection in this case was on statutory grounds, and we didn't assert that there was any other overriding interest of the state to maintain these records. So I was not the original prosecutor who reviewed this particular application, but everything that I've seen in this record shows me that, certainly he is an eligible offender, doesn't have too many convictions. And this is something that, quite honestly, we might sign off on. If there are no other statutory bars, it is something that we would sign off on and have in the past.
But this would still be subject to the trial court finding, doing the weighing of the interests and finding that he's been successfully rehabilitated, and the state choosing not to appeal if the trial court granted it, correct?
That is correct. That is correct, Justice Brunner. And the weighing of the interest, I think in reading the record, the applicant gives a pretty compelling interest, quite honestly, for wanting to have this record sealed. And it's not something that is, that we would have a countervailing interest. Certainly the records of the domestic relations court are not going to be affected by any sealing records. So those records that there was an arrearage at some point will always exist. So I think that even further diminishes what the state interest might be if we're talking about
counsel,
policy grounds.
Given your position that you just stated, I'm presuming because we're hearing this morning, you and Mr. Miller did not have a conversation about this.
We didn't have a conversation about this. However, the new law did not go into effect until 2 weeks ago. And it doesn't moot the overall argument, because the applicant's overall argument here is that Aguirre is distinguishable. I had contemplated filing a motion to dismiss, but again, it wouldn't have mooted his argument altogether. But the statutory grounds on which the state's objection would be based no longer exist, assuming that the new law applies, which again, under State versus LaSalle, a new application would be filed, and that would subject the application to that new version of the law. The sealing of a record of a conviction is a privilege and not a right, and that's what this court has stated time and time again, and courts of appeals
Mr.
throughout
Walton,
Ohio.
What about though the statute that says if you're an eligible offender and the court makes the two findings, the court shall grant the request to seal the record? How can we continue to say that it's a privilege when the statute says when these requirements are met, it shall seal the records?
Well, it continues to be a privilege because the General Assembly puts conditions in place. First, the applicant has to qualify as an eligible offender, as that term is defined. The specific case has to be eligible to be sealed, so there's no no prohibition against sealing that particular conviction. And then after that, there's the weighing of the interest. The applicant has to show that their interest in sealing the record is at least equal to the state's interest in maintaining the record. And then, of course, if all of those conditions are met, then the application is granted. But you know, if the General Assembly wanted to make this a right of some sort, they certainly would have the ability to do that. But up to this point, they have not. And as it relates to the final discharge language, I pointed out in the, or as pointed out in the state's brief, the language interpreting final discharge first occurred in 1983 and has been consistently applied both by this court and by other courts of appeal throughout Ohio.
Help me with how that works, because the language you rely on is that the final discharge doesn't occur until someone has completed all sentencing requirements. So that's easy if someone's in prison or jail. But if someone's on community control, they might be required to go to a drug test twice a week, and they may miss 10% of them. That person hasn't completed all their sentencing requirements, but I don't think you would say that they shouldn't be able to have their record sealed, would you?
Well, oftentimes we're relying on the record as it exists. So if the probation department hasn't filed a statement of violations and we're not aware of those conditions.
Say the probation department had. Say there was a statement of violations. The judge had the probationer in, said, get your act together, continue to monitor community control. So that person has not completed all the sentencing requirements. There were things they were supposed to do that they didn't do, but would we really say that they're not eligible to have the record sealed?
Well, in my experience, when looking at a sentencing entry, oftentimes it's going to be, sometimes there are specific terms where no positive drug screens. That's, you know, written into the sentencing entry itself. And if you have a positive drug screen, then you know, our position in the past has been, if you haven't satisfied the order as it is stated in that judgment entry.
So if someone on community control has one positive drug screen in the 5 years of community control, they can't ever get their record expunged?
Well, if the condition written into the sentencing entry specifically says no positive drug screens, then I mean, that would be the same as performing a certain number of community service hours if those hours haven't been satisfied, as was the case in Gainey.
But the reality is, I mean, for anyone who's been a trial judge, there are few people that you put on community control that with a drug problem that don't have at least some positive drug screens at some point. And you think none of those people are ever eligible to have their conviction?
Well, again, if it's specifically written into the entry that way, in my experience, very few entries actually read that way, at least here in Franklin County. But if there is a condition.
Counsel, you'd have language in there that You're on community control, you have to report to the probation department, and you have to obey all orders and rules and directives from the probation department, which is maybe not spelled out that you've got to have clean testing for the duration. But if that's what the probation, that's your written instruction from the probation, isn't that the same thing?
Well, our default position is usually if there is a termination entry that says successfully terminated, that overrides everything else.
Okay,
in
so
my
then
view,
your answer to Justice DeWine, it depends on what the judge determines is successful completion. It's not a black or white or yes or no. If you've had dirty urines or if you didn't show up to, whatever your appointments were for 5 years, if the judge wants to forgive that and give you a discharge, you got a discharge.
absolutely, yes. And if there is a successful discharge, I mean, the
But-
record.
But Counselor, I mean, I don't think all judges, some judges just say community control is terminated. They don't say it's successful. They don't say it's unsuccessful. They just say your time's up, community control, terminating community control, right? So
The entries that I've seen here in Franklin County, we have successful terminations. We have entries that say unsuccessful termination. And there are other entries just filed by the probation department sometimes that say they've completed the service of the term and are no longer on community control.
Right.
And so
So what do you do in that situation? There's no successful, there's no unsuccessful. How do you?
our default position has always been it's successful unless it says otherwise. Now, if there's an unsuccessful termination, as was the case here, and there's no dispute that it was unsuccessful here, then our inquiry goes a little bit deeper. Okay, what was the reason for that? Is that spelled out in the judgment entry? Was this a violation of that? Is there a statement of violations? What does that say? Did during a revocation hearing, did the applicant stipulate that they had violated? That's another consideration that comes in. So we look at these on a case by case basis, and our default position is to assume that they are eligible unless the record shows otherwise, or that they have a successful discharge, that is.
But you don't know what all the counties do in the state, correct?
No, I don't know what all the counties do. In Aguirre, though, that's why the language in Aguirre is so important. This court provided a clear framework within which to judge whether an offender has received a final discharge. And the language, all sentencing requirements, is clear in its meaning, and it provides guidance for many situations that a trial court might encounter in the context of a record sealing application. And the General Assembly.
Counsel, this payment of arrearages is a sentencing requirement in your mind, as opposed to, I think, a condition of probation, which is how I think Mr. Miller was making a distinction here.
Well, the arrearage is spelled out specifically, both in the sentencing entry, says follow the orders of the Domestic Relations Court as it relates to the order, and also pay the arrearage in the amount of $8,800 approximately. So both of those were spelled out in the entry as sentencing requirements. The General Assembly has amended 295332 now 22 times since 1983, when that phrase final discharge was first given meaning by the 8th District. And the statute has been amended 5 times since the decision in Aguirre. If the General Assembly wanted to change what the phrase final discharge means or what effect that it has, it could have done so at any point from 1983 up until now. And the fact that it has not been changed, despite all these other changes occurring to the sealing statute, it shows exactly what the General Assembly's intent is as it relates to that final discharge language. PJF was not yet eligible as the law in effect at the time applied to this application, wasn't eligible to seal the record. The 10th District properly reversed the trial court. And if this matter is addressed on the merits, I would request that this court affirm the 10th District. Thank you.
Thank you. Counsel, you've used your time. You may take a minute.
Thank you. In that minute, I would note, yes, Mr. Walton is correct. We just discovered the law for the waiting period for felonies of the 4th and 5th degree has changed from 3 years to 1 year. That law was passed April 12th of this year. That's great for lots of people. We are asking this court, however, to decide the case on the merits because at the time the child support was deviated to 0, that came after the sealing of the record hearing. The 10th District took judicial notice of that, but it said that 0 deviation does not affect the appeal. So
If I go through the record and I find out that this arrears was actually reduced to a lump sum judgment subject to another court order prior to this, does that make a difference? If it's already subject to a final judgment as a lump sum arrears, does it make a difference?
I would say I don't think so, Justice, because the reason is in our position is the $8,800, whether it be a lump sum or outstanding arrears, again, was specifically made part of his community control. So that number was testified, I think, at trial and presented by the Child Support Enforcement Agency. So all I can say is I don't believe it would make a difference. For all those reasons, we are asking this court to reverse the 10th District and reinstate the trial court sealing of the record. Thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marcia, we call a 10-minute recess.
The court will now take a 10-minute recess.
Our third case this morning is 2020-705, maternal grandmother as administrator of the estate of GB, a deceased minor, and maternal grandmother individually, versus Hamilton County Department of Job and Family Services, Hamilton County, Ohio, Denise Driehaus, Chris Monzel, Todd Portune, Shamira Stevens, AKA Shamira Hooks Ware, Cassie Setti, and Lamati Lavusa, and father of GB and mother of GB. For the appellant, Mr. Robinson.
Good morning, Chief Justice O'Connor, and may it please the court, I'd like to reserve 4 minutes of my time. 2-year-old Glenara Bates was tortured and murdered by her own parents. Those parents have been and will be held criminally accountable. But this appeal is about whether there will ever be any chance to hold the caseworkers, the family services caseworkers assigned to Glenara, responsible for wantonly and recklessly failing to do anything to stop her torture and murder. More specifically, this case is about whether plaintiffs will ever have the opportunity to conduct any discovery, to take any depositions, to look at any internal family services documents to determine whether Glenara was, how it was that the caseworkers failed Glenara. The trial court answered these questions. Should discovery occur? Should these caseworkers ever be held accountable? With emphatic no's. The Court of Appeals affirmed in a 2-1 decision. The Court of Appeals purported to apply Ohio's well-established notice pleading standards, but review of the analysis of that opinion makes it clear that instead the majority of the court subjected plaintiffs to a heightened standard of review. But there can be no question here that if the proper standard had been applied, the standard that this court and the lower courts have held time and time again should apply, the standard that this court made clear in New York always applies to governmental employee immunity cases, that this case would have survived the motion for judgment on the pleadings. The caseworkers here knew that Glenara's mother was an abuser before she was even born. Her mother had abused her 6 older children already, and all of them had been taken from her mother's care. Family services were present at the hospital the day that Glenara was born. They took her immediately from her mother's care. They knew how dangerous she was. 8 months later, a juvenile court returned Glenara to her mother. And 3 months after that, in December of 2013, even though Glenara's father, Glenn, had failed to ever comply with family services directives, family services terminated its supervision of the case. Then tragically, a year after that, in December of 2014, December 4th, 2014, Glenara was taken to the hospital, Cincinnati Children's, nearly 2 years old, a month from her 2nd birthday. She was unable to walk. She was unable to stand without support. She presented with flat affect. She had severe developmental delays. The medical records attached to the complaint make it clear that she also suffered from hair loss and that she was diagnosed with likely bilateral atelectasis, in other words, bilateral collapsed lung. Most shockingly, when she was born, Glenara was in the 90th percentile for weight and the 98th percentile for height. When she was taken to the hospital a month shy of her 2nd birthday, she weighed 17 pounds. She was in the 0.16 percentile for weight, the 0.07 percentile for height. And regarding head circumference, the medical records simply say she was in zero percentile. Even in the hospital, malnourished, famished, she wouldn't eat. She would not eat when presented with food until given affirmative permission by her mother. And her mother admitted to the hospital staff that she had intentionally withheld food from Glenara from the day that she first got custody of her a little over a year before that. The signs of abuse were blatant and obvious, so hospital staff contacted family services. Family services supposedly made one visit while Glenara was in the hospital, but she was admitted for 11 days. During that 11-day period, there is no evidence that they did anything other than a single visit, no evidence of any follow-up, no evidence of any safety plan, no evidence of any intent to remove her from her parents or to conduct follow-on visits. Fast forward then, Glenara is discharged 11 days later on December 15th, 2014. 3 months after that, on March 4th, 2015, for the very first time, Family Services conducts a home visit to Glenara. So we know she had all of these problems when she was in the hospital. At that home visit, she is pronounced happy and healthy, and the case is essentially closed. 3.5 weeks later, she's dead. She was tortured and murdered by her parents. The medical examiner said that her cause of death was battered child syndrome with acute and chronic intracranial hemorrhages and starvation. Listed the onset of that as months, and the coroner found that little Glenara had been abused, quote, her entire pathetically short life. She was covered with over 100 wounds, bruises.
Excuse me, Counselor.
Yes.
But when she was in the hospital for 11 days, there was no indications of physical abuse, were there? The doctors didn't report anything.
There were no indications of scarring or bruising of physical marks on her body. That's right. We would submit that forced starvation is indeed a form of physical abuse. But no, there were not at that time scars or bruises, whip marks, bite marks reported in the record. But we have to remember that there was a 3-month gap there. And according to the coroner, sometime over those, quote, months, those wounds were inflicted. We know there were scars, so we know that the wounds were not just inflicted in the 3-month period between that visit and her death. We know that the wounds numbered in the hundreds. So you are absolutely right, Justice DeWine, that there was nothing in the medical records in December showing that the bruising and the scars were present, but they certainly were present in that period between the discharge and the visit from the social workers. So we would submit that this case is really very straightforward. There isn't a universe in which family services workers could do a home visit, could find a child was happy and healthy, given all of these facts, without acting wantonly and or recklessly. So one of 3 things happened. Either they didn't do the home visit and just lied, said they did. They did do the visit, but lied about the outcome because they didn't want the trouble of another case, or they were so wanton and reckless that they missed these signs. They missed the signs of a bruised, tortured, scarred child who weighed somewhere at that point between 13 and 17 pounds. She was 13 pounds when she died. That they missed all of those signs. And we would submit that if this case can't survive a motion for judgment on the pleadings, that no case can. This court, as I think I had mentioned already, was very clear in New York that notice pleading standards apply to governmental employee immunity cases. That decision is 30 years old now, has never been challenged. The courts of appeals in the state are unanimous that the notice pleading applies here, with the only exception being the 2-to-1 majority in this particular case. As you are all aware, the court has from time to time in the past said that in very limited circumstances, heightened pleading is appropriate. For instance, in situation of intentional employer torts or of negligent hiring in the religious context. But those are very limited circumstances that have, this court has said have profound public policy reasons for those special rules. And they certainly have no application to this case. And I would point out as well that those cases too are roughly 30 years old. So it's been 30 years since this court has extended heightened pleading requirements beyond that very narrow subset of cases. And this certainly wouldn't be the case to extend it any further. Now, my colleagues observed in their brief, they took a very inconsistent view of exactly what should be pled and what was pled. First, that brief said that plaintiff, that Mrs. Bradley, had not been subjected to a heightened pleading standard, but instead failed to just show a nexus between the injuries that were investigated and those from which Glenara died. Then the brief goes on to state that the heightened pleading was required and that plaintiff was required to include facts, quote, beyond the operative facts of what occurred and must plead heightened intent. Now heightened intent isn't recognized, as far as I know, in the law of Ohio. Even under Rule 9b, the heightened pleading requirement for fraud, that rule is explicit that malice, intent, and other state of mind may still be averred generally. But our opponents go on to assert that animus should be required here. As we state in our brief, there's simply no basis for that in law, no policy basis for that as well. Finally, they conclude by urging the court to adopt the Twombly standard in this case, and presumably in all civil cases. Well, this court has had numerous opportunities to do that in the past and has repeatedly declined. At least as recently as 2015, the court said, no thank you to that, in Wells Fargo v. Horn. At that point, Twombly was already 8 years old.
Mr. Robinson, I don't believe that the other side argued Twombly in the appellate court, did they?
That's correct, Jim. They did not. But the other thing to mention about Twombly is that, ironically, after asking for Twombly, the court, or excuse me, my opponents say at page 28 of their brief that the facts as pledged show that it is, quote, at least equally possible that defendants acted properly here. So they're saying it's a 50-50 chance. Twombly says we need merely reach a plausibility standard, that we don't have to show probability, but mere plausibility. So even on our opponent's own standards, we have satisfied. I see that my time is going quickly, so I'd like to reserve the remainder. Thank you.
Thank you. Counsel? Ms. Sears?
Pardon me, Your Honor. Thank you very much. May it please the court and Justice O'Connor, thank you very much. This case presents as a combination of Rule 12C, which is inextricably intertwined with 2744-03A6B. If you'll pardon me, I'll just say 6B from now on going forward. That's best illustrated by the fact that recklessness, Your Honors, is a question of degree of breach. Since recklessness is a consequence of a degree of breach, then it is axiomatic that in order for the case to move forward at all, there needs to be a determination by the court that there is a cognizable private right of interest at play. In fact, I would submit for the court to go forward to the consideration of whether the facts are sufficient to ban the benefit of immunity at the pleading stage. Before the court gets to an examination of the sufficiency of those facts, there needs to be a determination of a cognizable right of interest. And I draw the court's attention to this court's decision in Graves, where I think the court made clear that in order to even delve into whether or not facts are sufficient to move the case into the discovery phase when 6B is implicated, there needs to be a determination that the statute at play, if there is a statute, or I would suggest to the court, absent a statute, then traditional tort concepts of duty suggest a cognizable private right of action. In their reply brief, appellants assert, for the first time, we are bringing up duty. I went back and reread the memorandum in opposition to the motion to amend the complaint. I went back and read our pleading with regard to our motion to dismiss the complaint. And in my mind, I went back to pre-litigation conversations with trial counsel. Throughout has been my concern is that my client, JFS, and these caseworkers did not have legal custody of this child. There is no general duty in Ohio to protect someone over whom you do not have control, or protect from that person from someone over whom you do not have control. Make no mistake that this case is not simply about Rule 12C. This case is not simply about Iqbal Twombly and whether this court would expand Rule 8 to incorporate plausibility. This case is not even necessarily about heightened intent, primarily from our perspective. It is about whether or not in Ohio, there is a general duty to protect children over whom you do not have custody against persons over whom you do not have control. That has never been established before, and this case, if reversed, will set that precedent. With regard to the, I think, can I say that appellant's counsel misapprehend the argument in the brief? I made the case for Iqbal Twombly. That's certainly up to the court. Court hasn't been willing to go that far or has found the necessity to enlarge Rule 8's traditional Ohio concepts to incorporate plausibility. It's nevertheless apparent when one surveys the panoramic view of your inferior courts that your courts in fact are adopting to a degree plausibility. And I find it, I would find it odd if anyone could argue that, for example, in Maine versus, I think it was Cipollone versus Hoffmeyer below, the court said, you know, we're not going to incorporate wishful thinking into Rule 8. In Toledo, which we relied on at the trial level and also at the appellate level, the court said ease of entry that exists as a result of Rule 8 and Ohio's application traditionally of no set of facts entitling you to relief. Certainly does.
Excuse me.
Yes, go ahead. I'm sorry.
This whole the Twombly conversation to me seems beside the point. I mean, this is about, Twombly is really about plausibility. It's about
Right.
whether or not a set of facts is plausible. But that's not really the issue here, is it? I mean, I think no one disagrees that their claim is plausible, that that there was a failure to know what was going on here. But the real issue here is the specificity with which allegations need to be made. That's not really a Twombly issue, is it? I mean, Twombly wouldn't change anything here, would it?
Well, I understand what you're saying. I don't know that I wholeheartedly agree, but I do very much appreciate what you're saying. What I see when I survey your inferior courts and the filter or the analysis that they bring to the question of whether the case sounds in negligence or whether it sounds in something beyond negligence, so that the benefit of immunity would not apply at the pleading stage. I see the lower courts incorporating not only the Rule 8 standard, but infusing it in a way that, frankly, I don't find offensive with considerations of plausibility. By that, I mean mere speculation, conclusory legal statements that aren't supported by facts, wishful thinking. So when at least when we were looking at this case and considering plausibility, Justice DeWine, that's what was in our mind, that incorporating those concepts into our traditional analysis under Rule 8 is not offensive to Rule 8. It doesn't remove us from the traditional parameters of Rule 8, and a survey of your inferior courts reflects that the lower courts are infusing their Rule 8 announcements, or excuse me, analyses with plausibility. But to your question,
why does the York case not control in this particular case?
In what fashion? If you mean in terms of York saying there's no heightened pleading standard, I think York is absolutely controlling. It's absolutely controlling as we all sit here having this conversation. I noticed in York that the court was critical of the position in York because there wasn't a public policy suggested by the defendants in that case for supporting heightened pleading standard. When I looked at 2151, I should say when we did, I could see a public policy that would support a heightened pleading standard, but I have to agree with you. I don't know that a heightened pleading standard, in fact, I would suggest to you, is not necessary in this case to resolve the case in our favor. And I guess that's my response to appellate counsel's characterization of the brief. It misapprehends the arguments. The court accepted this case. This case is a case that stresses and points out the tension between the application of 12C under Rule 8 and 274403 A6B. And in that regard, there are any number of approaches the court could take. And what we sought in our brief was to elucidate what those were. Frankly, the manner in which the lower courts in the state are applying that filter, applying that analysis, using what in David versus Matter, the court described as a heightened intent standard, really reflects what the court did in DiGiorgio, reflects what the court did in Toledo. And with all due respect, reflects what the court did in the case that Justice Stewart sat on, Bowman versus Downs, as well as Amron versus Tell, as well as David versus Matter. In all of those cases, the court did not look to what the plaintiff pled the case as. Did you plead it as negligence? Did you use the magic words of recklessness, etc.? No, the court looked at what were the facts alleged in the complaint, and were they sufficient to move the case beyond one that sounded in tort. And that's why I think in this case, it's elucidating to look at the actual complaint in this case.
Ms. Sears, I
Yes,
wanted to get to that point, but I want to, this is Justice Bruner here.
Oh, I'm sorry, Justice Bruner. It's a little, it's hard to tell whose lips are moving sometimes. I apologize.
No worries, no worries. So how would, getting to the complaint, how would this case or your argument or your issues about public policy be different if, there was a credible source that contacted Children's Services, which was a hospital,
Yes,
but
ma'am.
how would it be different if the agency had no prior contact with this family? How would it be different if the agency had not taken this child away from its mother at birth and been aware of the history of family violence and abuse and neglect?
So that's a very interesting observation. And I have given that great thought because one of the things that has been problematic and troublesome is the structure of 2151, the chapter, as well as 5153, which are the obligations and duties of JFS in this context. Clearly manage or attempt to the tension between what this court has described, Justice Lanziger and O'Toole, as the basic and essential right to raise your children versus obviously the overwhelming effort on behalf of government to intervene when you are doing so in a way that causes the child harm. And so in this particular scenario, for example, the juvenile court gave the children back, reinstituted custody. Protective services was terminated, not only at the recommendation of our client, JFS, but also at the recommendation of the guardian ad litem, who represented the interest of the children individually who are plaintiffs in this action. And that's apparent from the pleadings and the public records attached to the pleadings. So,
but as a matter of granting a motion for judgment on the pleadings, if the only thing that had happened was that the hospital called Children's Services out of the blue, there'd been no prior contact, and then the same result ended up, does that affect the duty or the relationship between the parties in terms of whether or not the trial court could grant a motion for judgment on the pleadings?
well, two things. One, had there been some report at the time of the hospitalization of physical abuse, which in fact was the prior report and was substantiated, and why the children were taken away from this mother initially, then I could see an argument, Your Honor, that yes, there would be some argument that there was some sort of knowledge that would infuse this analysis. The fact is that is not the case here, that there was no allegation of physical abuse, and there had been no allegations of starvation and that kind of thing before known to the agency, at least from the pleadings, we'll say.
But counsel, let me stop you there. The child presented at the hospital. Initially, they called CSB, right?
Yes, ma'am. They're mandatory reporter. Yes, ma'am.
All right. What triggered that mandatory report?
A concern on the part of the hospital that this was a case of neglect, either socially caused or organically caused. As the child was admitted into the hospital, the medical professionals were not sure. As the child was released from the hospital, according to paragraph 24 of the complaint, the doctor at the hospital ascribed the failure to thrive to three things: a lack of medical care, financial hardship, and lack of family support. Interestingly, when you look at the medical records that are attached to the pleading, this is what you see. The mother voluntarily brought her child to the hospital. According to the medical records, from the time that she regained custody of the child to approximately 14 months, she brought the child to the emergency room on at least 3 or 4 separate occasions. When you look at the medical records, it's apparent, at least it says in the medical records, that she ran into a problem with insurance. And so that the last ED visit before this one she engaged in, there was a problem with her insurance. I don't think anyone would suggest that because someone has problems, they have financial hardships, that we should remove their children from them. I don't think anyone would suggest that because someone has a lack of familial support, that we should remove their children from them. And I don't think anybody would suggest that because someone, because of their financial hardships, finds it difficult sometimes to get medical treatment, that we should take their children from them.
Well,
But that is
the
what the
fact-
medical records say.
Counsel-
I'm sorry. Yes, ma'am.
So the fact that this baby needed to be in the hospital for 11 days as a result of the condition that she was in when presented to the hospital, no matter whether it was, they were, financially stressed, they didn't have, family support, but there was no doubt about her malnutrition and her physical condition.
That's correct. And the reason she was in the hospital for 11 days was for the hospital to rule out an organic cause of failure to thrive. The other thing the hospital records clearly indicate is that her caregivers were present at the time the hospital expressed to them what the issues were and what the appropriate response going forward would be to rectify the situation. And the hospital records attached to the complaint say the caregivers were responsive to that.
Okay, so basically what the instructions were, you've got to do a better job and here's how you do it. That was given, that was the instruction to the parents, correct?
Well, unfortunately, Your Honor, we're tied to what's attached to the complaint. So what we do know from the complaint is that the caregiver was present and was responsive. What the complaint alleges is the failure to intervene and allow the child to be discharged to her mother is the factual nexus to the her ultimate murder, and also the failing that presents liability for JFS. Also, the failure then to remove the child. The complaint actually reads in paragraph 38, had the continuing abuse been reported, Janera Bates, the child, would not have been in the home in order to be killed. If you read paragraph 38, 37, and paragraph 2, what will become apparent is what was alleged in this case was a failure to report the continuing abuse to law enforcement creates liability. And this court has been very specific and adamant that there's no cross duty to report. I see that my time is running down, Your Honors. What I would suggest is that a reversal of this case will establish in the state of Ohio a general duty to protect children for whom someone does not have custody from the actions of a third party over whom the person has no control. And I would also caution, as the court has cautioned, that the tragedy of this death is apparent. That fact cannot enter into a reasoned application of the law and determination what the law is in the state of Ohio. And that was the caution in O'Toole, and that is the caution in DeShaney. And yes, I'm sorry.
It's Justice Bruner again.
Oh, thank you. I'm so sorry.
So you said that the allegations in the complaint in terms of what basically Children's Services did wrong were
Yes.
the release of the child to the mother and the failure to report continuing abuse to law enforcement. Anything else?
The paragraph in paragraph 38 says, or excuse me, 37, failure to report, quote, let alone remove, close quote. There are other allegations in paragraph 37 that center around the judicial court's return of the child, which I think have been sort of winnowed out as the case has promulgated or so percolated up to you guys. But at this point, I think all that's left is the allegation that there was a failure to prevent discharge from the hospital to the custody of the mother, and then failure to report the continuing abuse, which allowed the child to remain in the home in order that she was present to be killed by her father.
Counsel, what about the home visit? How do you see that? The home visit where there was clearly a report made that did not comport with the condition of the child.
So my issue with that, Your Honor, is this. That argument is based on an autopsy that was done about 3 weeks after the child was seen by the caseworker. In that autopsy, as the court well knows, having, I think, presided over the death penalty case, there were reports of the abuse to the child. What is missing from this complaint, frankly, is to what extent those injuries may have been or should have been apparent. Certainly, the caseworker, who is not a nurse and is not conducting an autopsy, cannot see healing fractures. Interestingly, at the hospital in December, the doctors noted that the problem walking preceded the problem with nutrition. Yet the hospital didn't do a skeletal scan. Had the hospital done a skeletal scan in December and suggested, as Justice Bruner suggests, that there were some kind of physical issues, we might be having a different conversation. With regard to that visit, I believe the problem there is an inference upon an inference. So you're inferring that certain injuries, which you don't identify in the complaint, in fact, this isn't really well pled in the complaint at all. This is more of a function of motion practice after the complaint. But you don't plead which of those injuries should have been or were apparent. You then infer that because certain injuries should have or could have been or likely were apparent, that the caseworker either saw them and didn't do anything about it, or in fact lied and didn't go there. This is an inference upon an inference. And it's well settled that you can have multiple inferences from a set of facts, but what is impermissible is to have an inference upon an inference. And I think that is the legal problem with that argument, Your Honor.
Isn't there a duty of any children's services to identify when a child is in danger? Isn't that kind of a public duty? Isn't that why the agency, one of the reasons the agencies exist?
So I would agree with you that certainly investigating the possibility or the report of suspected abuse and neglect is a function of the agency. I would absolutely agree with you. My issue is, as the court in O'Toole noted, the three separate sort of categories of when that duty realizes itself. Okay, in the emergency removal of a child, as the Grimm case suggested to the court in O'Toole, in the protective services or protected services scenario where the court has ordered the agency to provide protective services, which is the case in Jackson, in which the court found that there was no recklessness. And then lastly, the case in Hahn, where the agency had custody of the child. It was a foster situation. I don't think there's any doubt that to the extent the agency has custody or the extent that the agency has control, that there's a duty to protect. But where the agency is investigating potential abuse and neglect, although there is a duty to investigate, I don't think that the statute then parlays that into a general duty to protect during that investigation.
So is there ever a
Also,
duty
there's
to
a
report a
mandatory
crime?
duty to report, but no duty to do anything about it. Is that?
Well, this court has held that there's no liability for a failure to investigate, which also brings an interesting question. If there's no duty for a failure, if there's no duty to investigate for which there's liability, then the question becomes, if you undertake a investigation, how is there a duty created? The General Assembly has not suggested that there is a mandate for a particular mandate that is the conclusion of an investigation. The agency can sustain abuse and not remove children. The agency can sustain neglect and not remove children. So there is no duty to remove, there's no duty to take custody of children. There is a duty, Justice Brenner, I would wholeheartedly agree, for the agency to investigate. And one of my concerns is that—
What about to report a crime? It has a duty to report crimes if it observes them in its investigation, correct?
there is no duty to cross-report from the agency to law enforcement. The agency is the agency to whom abuse and neglect is reported. So I have had cases when I was prosecuting criminal cases where there were child endangering that we were engaging in prosecuting an individual on, where law enforcement was not involved, and some where they were. So you are correct. There are times when there's a report, generally speaking, in my experience, that report starts out as a crime that then law enforcement reports to the agency, and then the agency conducts their investigation, has been my experience, as opposed to at the agency receiving a report of abuse and neglect, investigating it, and reporting to law enforcement, with the potential exception, I suppose, of a sexual offense.
That's probably what was the impetus for Franklin County to kind of combine everything into one center, where prosecutors, child enforcement agencies, and the hospital at Nationwide Children's Hospital actually kind of come together with an integrated, comprehensive approach that's not available in Cincinnati, correct?
No, actually, we have a Mayerson Center here, Your Honor, which is exactly that, where we have a concentrated approach involving medical, social services, as well as law enforcement when a crime is implicated. So we have that ability here, and that does happen. And I didn't mean to suggest that it didn't happen. I just don't, in my experience, necessarily believe that every abuse and neglect that's reported to the agency translates into a criminal matter. Although it certainly is true that that can be the case and does in fact happen.
Thank you.
Thank you.
Thank you very much.
Counsel.
Thank you, Your Honor. With the court and the clock's indulgence, I'd like to run through 4 or 5 different points quickly if I could. First, counsel asserts that this case is about duty. The court has made clear in Argabright and in Cleveland versus Moore that whether a governmental employee is entitled to immunity is a separate question entirely from whether the elements of the underlying claim have been established. They're totally separate inquiries. Counsel asserts that they have preserved the duty argument because they raised it, quote, in their motion opposing, or rather the brief opposing the motion to amend the complaint. What she doesn't say is that it was raised in their motion for judgment on the pleadings or in the Court of Appeals. So that argument has in fact been abandoned. But as stated, it is meritless regardless because the court has made clear that duty and immunity are totally separate inquiries. Next, regarding the assertion that the court has held that there's no...
Mr. Robinson, I think what your opposing counsel was saying was that you don't even get into immunity if there's no such duty. Is that what, so, I mean, how do you deal with that?
Well, we would deal with that here in a couple of ways. First, that wasn't argued in the motion for judgment on the pleading, so it's not before the court. Second, the court has said that the threshold issue is the immunity issue. It's not the underlying duty issue. You know, if there's duty breach, cause and fact damages, you know, whether the underlying claim is properly pled. The first issue, the threshold issue, is immunity, and that is the issue that the court granted on. Next, regarding the
counsel, just for purposes, I'm kind of rehashing what opposing counsel said. This child was identified, if not abused, neglected by the hospital record several weeks before she died, correct?
That's correct. Several months, Your Honor.
Several months before she died. Okay. And then that obligated CSB to investigate and continue with the case. Am I
That's
right?
right. That obligated family services to start an investigation. That's under, I'm sorry, go ahead.
Okay, so the investigation, I mean, they have a case involving this child. From what, upon the discharge of the hospital, I think the record reflects they went to the home once. Is that correct?
That's correct, Your Honor, 3 months later.
And that's the level of their investigation.
That's right, which is contrary both to statute and to the Ohio Administrative Code. So 2151.421 F and G require the investigation, require that it occur within 24 hours after the report. So we know that the report happened at the beginning of this stay. So presumably, the second day of the stay, they started their quote unquote investigation. Now, the Administrative Code 5101 says that they're required at that juncture to fill out the JFS form 1401. That form has a number of questions that they have to answer. And in the end, they have to reach one of 4 conclusions. This is really helpfully set forth in our amicus brief from the Justice for Children Clinic. But they have to say either that the child will be taken out. There are 2 different mechanisms for taking the child out of the home. They have to say that the child is safe, which means either there is no threat to safety or that the family is keeping the child safe from the threat, or they can allow the child to stay in the custody of the parents, but they must conduct weekly visits thereafter. That's clear from Administrative Code 5101:2-37-02. I think it's part G of that, but it's clear that they have to do weekly visits. And there's no question here, according to the complaint, those absolutely did not occur here. Regarding the financial hardship inquiry, the record makes clear that in fact, the issue here was not financial hardship, but that the mother did not want to feed the child. She thought she was overweight. Regarding the idea that she was kept in the hospital for those 11 days because they wanted to tell if it was a social or counsel said organic cause, that's incorrect. That's not supported by the medical record or the complaint. Rather, she was kept in, presumably the inference is to wait to see if family services would actually get anything done and to see if they could get her above a starvation level weight. The inquiry is sociological versus biological factors, and the medical record makes clear that biologically caused failure to thrive was ruled out immediately. It was sociological, and that is a politically correct way of saying that her parents were starving her. I see that my time is well past expired, so I would urge the court to reverse, to stem the tide of a decision that is an anomaly and that could cause so much damage down the road. Thank you.
Thank you. Thank you. We'll take the matter under advisement, counsel, and you'll be notified of our decision. Our last case this morning is 2020-819, State of Ohio versus Clarence Lay. For the appellant, Ms. Spriggs.
Thank you, Chief Justice. May it please the court, my name is Addison Spriggs, and I'm here on behalf of Mr. Clarence Lay. I would like to reserve 3 minutes for rebuttal. When an appellate attorney fails to include portions of the record which are necessary to determine the outcome of the issues raised on appeal, the appellate court cannot meaningfully review the assignments of error raised, and the appropriate mechanism for relief is to reopen the direct appeal. An appellate attorney must comply with the rules of appellate procedure. Here, Appellate Rule 9B, to ensure the record is complete and includes the transcript of the trial court proceedings. Counsel's failure to complete the record cannot prohibit a criminal defendant's right to meaningful appellate review and constitutes a colorable claim of ineffective assistance of counsel enough to sustain an application to reopen a direct appeal. This is directly contemplated.
Why not just make some argument about what was in the record? Show those prejudice.
The Court of Appeals found that there wasn't enough of a record for it to reach the merits of the assignment of error.
I understand that, but why wouldn't you on appeal say, here's what's in the record? This raises a colorable issue. If the Court of Appeals had the record, my client might have been successful. Why not make that argument?
That was the argument in the 26C. I said that appellate counsel was ineffective for failing to include the record. And Appellate Rule 26.
But what was in the record that would have changed the outcome? That seems obvious.
None of the transcripts were in the record at all.
Okay, I didn't mean in the record. I misspoke. What was in the transcript that had it been in the record would have changed the outcome?
Well, we don't know because the transcripts were never created or included in the record. This is directly contemplated in Appellate Rule 26B-2C, where the assignments of error aren't reviewable based on the incomplete record.
You could get the transcript, you could find out what happened at trial, and you could make an argument based on that, couldn't you?
It would have been inappropriate to include the transcripts with the 26B motion.
Why?
Because the rules specifically, yes, Your Honor, because the rules specifically say that you should point to the portions of the record that are available at that time. And if the transcripts weren't ever created, they weren't available and they weren't a part of the record. So following the rules of 26B, it would have been inappropriate to include the transcripts at that time. It's more appropriate for a pro se defendant who has a right to counsel on direct appeal and right to transcripts at state expense to include the transcripts once the appeal is reopened and it proceeds as a direct appeal.
But you certainly could have ask to supplement the record with the transcript to show that there was an issue, couldn't you?
That is possible, but again, it goes back to the rules of Appellate Rule 26, where it says to point to portions of the record which are available to the appellant at that point. And because the transcripts were never created or included into the record, pointing to the language of Appellate Rule 9, where we get the definition of what the record is, it wouldn't have been appropriate to point to something that was outside the record. Mr. Lay did not receive a merits determination, and that is the prejudice here. His case was entirely precluded from review by the actions of his appellate counsel. While there's no case law defining the outcome of an application to reopen in this way, this court in State v. Reed defined prejudice as a reasonable probability of success if the assignment of error was raised on direct appeal. This reasonable probability is not guaranteed success. Here, in an appeal without counsel's failure to file the transcripts and the PSI, which would have supported the issues raised on appeal, there is a reasonable probability that the Court of Appeals would have decided the case differently. That is, that they would have made a merits determination. Arguably, the situation here exceeds the Reed standard of reasonable probability. It is a certainty that the Court of Appeals would have reached a merits determination with the transcripts and the PSI included. This situation before us is directly implicated in Appellate Rule 26B2C.
Counsel,
Mr.
Counsel, you're relying on 26B, but doesn't 26B2C require prejudice, a showing of prejudice?
Yes, and there is a showing of prejudice here on the face of the Court of Appeals decision, where it said it could not reach the merits of the argument. So it's not necessarily guaranteed success on the underlying assignments of error. It's that it would have been a different outcome and that he would have had some sort of merits determination.
Wouldn't you need a reasonable probability of a successful merit determination?
Yes, and we have that here. While this isn't a case where, take for instance, merger of arson and check cutting. I can't envision a situation where those two crimes could have merged. But here we have gross sexual imposition and sexual imposition, and very frequently those merge. And we also have a showing in the sealed portion of the record, which supports the fact that there were one victim and two separate instances. And the gross sexual imposition charges are alternative charges.
So given that fact, if that's undisputed, usually the state just concedes that the trial court made an error at the appellate level. Why didn't that happen in this case? I mean, is it undisputed that this person was sentenced on 4 consecutive counts for only 2 incidents, right?
Correct, Your Honor.
That they were 2 alternate. The reason there were 4 counts, there were alternate theories, but it seems undisputed that it's an incorrect sentence, right?
We can't necessarily reach the merits of that issue here. It would be more appropriate once the transcripts are in the record. Mm-hmm. But to the state's credit, they didn't oppose the motion to reopen the direct appeal.
It was the Court of Appeals that?
Correct. The Court of Appeals denied the motion to reopen and then also denied the motion for reconsideration and en banc review. Okay. The state didn't oppose either.
So, counsel, are you asking us to say that it is ineffective assistance of counsel per se if the hearing transcript or any other relative transcript from something pertinent to the issues before the court is not filed? It's just ineffective.
Yes, Your Honor.
without a showing of anything more.
I think there needs,
Likelihood of prevailing, that there was actually something that could have been identified in the transcript to bolster, the allegation of ineffective. None of that has to happen. It's just if you're a defense attorney, you do not file the transcript, the appropriate portions of a transcript with the court on appeal, that is ineffective assistance per se. That's what you would like us to write?
I think that would be the simplest way to do it, Your Honor. I think that, this court could find that a bare assertion, something that is non-frivolous, but not necessarily guaranteed success, would also be an acceptable rule. And I think that Mr. Lay has that here.
Counselor, before we get to the rule, though, whether it's non-frivolous or what, I mean, the underlying issue here is what kind of showing do you have to make? And I want to go back to your statement that you weren't allowed to file the transcript. You couldn't file it under Rule 26. Because when I look at that rule, it says very clearly that the application shall contain parts of the record if available, but also may include affidavits from counsel. And clearly you could attach a part of a transcript to the affidavit. There's no reason you couldn't have done that, or counsel couldn't have done that, is there?
I think
should we assume that the reason that wasn't done was because the transcript wasn't helpful or wouldn't have been helpful?
No, I don't think you can make that determination at this point. That part of the language, Part E, any parts of the record available to the applicant, hasn't been defined. And there's no cross.
Wait a second. You read half of that sentence. Any parts of the record available to the applicant and all supplemental affidavits upon which the applicant relies. The rule clearly envisions that in addition to the record, because that may not be available, that counsel can file supplemental affidavits, bringing in things to show that counsel was ineffective. So why not do that?
The reason not to do that is because this is merely a procedural step, and often 26B is used
but the procedural step specifically says to file supplemental affidavits. I mean, it clearly envisions that is part of the procedural step, not as coming later.
I understand that, Your Honor. I go back to the fact that any parts of the record available to the applicant and supplemental
affidavits.
Yes, Your Honor. That portion of the transcript wasn't available in the record, and you're here within a limited amount of time to complete an application or a motion to reopen. So there's a strict 90-day time limit. And for a pro se defendant,
you could have filed an affidavit that said, here's what happened at trial. I've tried to get the transcript. It has not been prepared yet. I was unable to get it prepared. You could have done that.
That would have been an option, but again, it goes back to whether or not, if the transcript isn't created, I couldn't attest to the fact of what would be in the transcript if it wasn't completed in that 90 days.
Well, someone tried the case, didn't they?
They did try the case, and that same attorney was the.
Ms. Briggs, I want to simplify a little bit. The precedent that you provided from the U.S. Supreme Court in Roe v. Flores, Ortega, and Garza essentially says that when an attorney's deficient performance deprives a defendant of appellate review, there is a presumption that the attorney's performance caused the defendant prejudice. So I think the only nexus we have to be able to draw is whether the failure to file a transcript denies a defendant appellate review. Am I right about
Correct.
that? And
yes, Your Honor.
Is there any scenario you can think of where not filing a transcript wouldn't deprive someone of appellate review?
I can't envision a situation, Your Honor, and I think that there are several cases that directly contemplate, actions the court could have taken with in the absence of a record. And Appellate Rule 9 also contemplates the fact that an appellee may supplement the record if a certain transcript was omitted.
Because it's possible sometimes, I've seen at least, where based on the issues being appealed, the entire transcript may not be ordered up and provided, only relevant portions, in which case then the other side could supplement it if they felt that some were missing, correct?
Absolutely. That's directly contemplated in Appellate Rule 9.
Thank you.
I see that my time is running down. If there are no further questions, I would like to reserve the remainder of my time for rebuttal.
Okay, thank you. Counsel?
May it please the court, Madam Chief Justice, this is Heaven DiMartino on behalf of the state of Ohio. I am asking that this court affirm the appellate court's decision denying the motion, the application for reopening filed pursuant to Appellate Rule 26B, and to reject the proposition of law that's been asserted by Mr. Lay. An Appellate Rule 26B application for reopening only has to be granted when there is a colorable claim of ineffective assistance of counsel, and the failure to include portions of a record from the trial court do not automatically per se create a situation where there is a colorable claim of ineffective assistance of counsel. There can be situations where someone is challenging specifically a plea. Maybe it wasn't knowingly, intelligently, voluntarily made. Failure to include the transcript from the sentencing or a pre-sentence investigation would have no bearing on the issue raised by the appellant on the direct appeal. In fact, when you looked at an Appellate Rule 26B application for reopening, you really are limited to what was presented by the first appellate counsel. And in this case, the specific issue raised by Mr. Lay's first attorney was that the court failed at all to engage in an allied offense merger argument. And the journal entry specifically says that the court did, in fact, conduct an allied offense argument and that no one objected to it. So when you have a situation like this, certainly the PSI has no bearing on that assignment of error. What could be contained in a pre-sentence investigation would have absolutely no impact on an argument that an analysis occurred or did not occur at sentencing. And when you have a journal entry that says something occurred, the sentencing transcript is not going to be necessary. It's not going to be something that an appellant could say they were prejudiced by the failure to include that and that it would have changed the outcome if the sentencing transcript was included. And to get to justice, I'm sorry.
Let me ask you this. Do you agree that it's not only a colorable claim in this particular case, it's not only a colorable claim, it's like, it's a claim that everyone agrees on. It's a meritorious claim that this defendant is serving an incorrect sentence.
Correct.
So why is the state even? I mean, the state has an obligation to pursue justice and make sure that trial courts get it right, just as defense counsel, right?
Right. And in this case, the journal entry reflects that an analysis was done. There's nothing in the record, and there's no, as Justice DeWine was asking, there's no statement by appellate counsel that even if she had talked to her client to say, I know the journal entry says that there was an analysis done, but it was not in fact done. And I don't have the record below. So I'm going to presume that the journal entry is correct and that, you know, a court speaks through its journal entry. That's axiomatic, that the court says it conducted the analysis and that no one objected. No one in our office, you know, asked for the journal entry to be corrected in any manner. So I'm limited to that record below. Certainly, Ms. Spriggs, when she filed her App Rule 26B motion, could have said this journal entry is inherently flawed because there was actually no analysis. She's not even saying that. She's given this court absolutely no reason to discredit what's been journalized by the trial court. So with this unique set of facts, there is no basis for which one could say there would be a colorable claim that could have been presented if the transcript had been included. Certainly, if this counsel is indicating to this court that that journal entry was blatantly wrong, then something could have been done about that. She certainly could have put that in her statement, and there's nothing before this court to indicate that is what happened at all. With regard to the inquiry as to whether or not a transcript, is always needed even when you're looking at a sentencing issue, unless you're looking at specifically whether the court analyzed, let's say, aggravating or mitigating factors in a certain way, and whether they should have or should not have imposed a prison sentence or a consecutive sentence or a maximum sentence. Certainly then a pre-sentence investigation would be relevant, and certainly the transcript will be necessary. But if the only argument is, let's say, the appellant says the court imposed mandatory time and by statute that's not mandatory, then you would not need the transcript and you would not need the PSI. So this invitation by defense counsel to extend this conclusion that anytime the entire trial court docket, transcript, PSI, anything that was filed in the trial court is not included for the Court of Appeals review is just too broad and something that is really not necessary, because not every issue is going to be raised on appeal, and it is not the appellate court's duty to root out an argument for an appellant. So if the appellant wants to, have an attorney who files a very specific one issue on appeal that says there was no allied offense doctrine of merger analysis done, and then the journal entry shows that it was, that's the end of that. Ms. Briggs certainly could have filed an April 26B application for reopening saying appellate counsel was ineffective for arguing that there was no analysis when the journal entry reflects that there was an analysis. And if she had done that, then you would have needed a transcript and perhaps the PSI to get into the merits of that claim. But when you look at the motion for reconsideration and the entry that was put out by the 9th District Court of Appeals, as well as their journal entry on the motion for reconsideration, it's very clear what the court is saying is that this is not a case where the transcript or the PSI was needed because of the issue that was raised on appeal and what is actually contained in the journal entry. So this case is completely distinguishable, as Justice Bruner was inquiring about Flores-Ortega and the cases that are cited by the appellant. Those are cases where there was forfeiture of any appellate review because there was no appeal perfected. That's not the case here. There was an appeal perfected. There was an argument raised. It just was not a good argument in the state's opinion based on what the record contains.
Counsel, let me ask you, you're saying it, excuse me, just it wasn't a good argument, but if appellate counsel argues an issue on appeal that does require the transcript and it's not submitted, isn't that essentially no counsel?
I would argue that Appellate Rule 26B would provide a remedy to reopen. So if you have a situation where there is an argument raised on appeal and there's something in the argument that should have been contained in there, then that falls within Act Rule 26B. And if an attorney raises an issue that's just wrong, and I mean, unfortunately, I have seen it where someone has raised, an appeal issue, they'll say, there was no finding by the trial court for consecutive sentences. And then you look at the transcript and you look at the journal entry and it's in there. Well, then maybe you make that April 26B motion to say, hey, that argument was so bad, or however you want to phrase it, right, that you didn't have appellate counsel. April 26B is there to protect you for that. You would file the necessary application for reopening. You would attach the transcript. You would attach your statement, and then the court would grant that.
But you're saying you would attach the transcript for April 26th, but if an appeal is filed, noting, assigning as error something that requires the transcript, and that's not done, why isn't that in and of itself like having no counsel at all?
Because, like I said, Appellate Rule 26B, you would be able to have that reopened. So that's a mechanism that's in place to take. So if you want to articulate it or qualify it as not having counsel at all, April 26B will allow you to have it reopened, and then you will have counsel. So you will not be forfeited from that review. In this situation, there was a review. It just was based on an argument that is not supported by the record. So again, if the April 26B motion had said trial counsel was in effect.
When you say not supported by the record, what do you mean specifically?
Because the journal entry in this case, unlike any of the other cases I've seen where there was a sentencing issue where the transcript or PSI was not attached, and that was a basis for the granting of an application for reopening. In this case, the journal entry says, in fact, there was an analysis done by the court, and on top of that, no one objected.
What if that analysis was wrong?
then that would have to be the issue raised on appeal. If appellate counsel in the direct appeal or in the April 26B motion said the reason why the court was wrong or the reason why the April 26B motion should be granted is because the trial court's analysis was wrong, that's a completely different scenario. That's not what we have here. We have a situation where the only assignment of error argued, there was no analysis done at all. They didn't challenge the adequacy of the argument, whether the court applied the right standard, whether the court applied the facts that were in the PSI. That's simply just not before this court, which is why the cases cited by appellate counsel are distinguishable. The 6th district cases that she cites to NRA LN talks about the timeliness of a classification hearing. That you need the transcript to see when did this actually happen. NRA White talks about consecutive max sentences. You would need a transcript to support the court's imposition of consecutive and/or maximum sentences. Lay did not get a maximum sentence here, and there's no argument that the court erred in its analysis for consecutive sentences.
Ms. DiMartino, but you know, maybe there was no correct objection to the analysis on merger. Still, even for plain error, you still need a transcript, don't you?
For plain error, in this case, you would have to show as the appellant that the trial court committed plain error by stating in its journal entry that it had conducted an allied offense argument, and also plain error by stating in its journal entry that neither the state nor the defense objected to the court's analysis. So because that is what the plain error analysis would be limited to in this case, the journal entry is sufficient to answer that question. You would not need a transcript to answer that specific issue. If, again, appellant had argued even plain error in the court's analysis of the allied offense argument, then you would need the transcript, but that's not what the appellant in this case argued, which is why the cases that talk about forfeiture of appellate review are inapplicable here and are distinguishable. The 6th District Court of Appeals cases, like a suppression issue, she raises the Carpenter case, that involved a journal entry about a suppression without having the transcript to support what the findings of fact were, which we have to look at whether there's competent, credible evidence in the record. So you need a transcript for that.
But I thought you were pointing to the fact, though, that the issue about that was in the journal entry about the allied offenses, that wasn't raised, but it could still be looked at under plain error, but you still need a transcript to know what the trial court said in making its analysis.
It can be looked at if it's raised. It was not raised in this case.
But when an issue is not raised below, or you know, it's rather than waiver, plain error in the right circumstances can be used by the court to try to achieve justice.
I agree, but I agree with you that plain error would be the standard of review, but that would be.
But you need a transcript for plain error.
You need a transcript for plain error if you are looking at an analysis of factors of evidence that's presented. In this case, you're looking at an analysis of plain error in what the court journalized. And there's nothing in this record to support a conclusion that the trial court erred, let alone committed a plain error, when it said, I conducted an allied offense argument. And when I was done with that analysis, I said the 2907-05A1 and 2907-05A5 do not merge, which I would argue in contradiction to Mr. Lay, those are not going to merge. One requires substantial impairment, one requires threat.
How do you know without a transcript? Just, I mean, how do you know?
Well, the 05 and the A1, you can argue without a transcript because they require different elements and different animus. So in this case, you're really only looking at whether the 05 and the 05 merge with each other and the A1 and the A1 merge with each other. But either way, that is not before the court. That's not an issue before the court. The only issue is plain error as to the argument raised on the direct appeal, which was that the court did not do any analysis at all. So you do not need a transcript for that. This case is just different as opposed to a case where the journal entry was silent as to whether or not there was an allied offense argument. And also because the issue raised on appeal did not get into the merits of the analysis. It was just whether or not the analysis occurred. So under this set of facts, it's distinguishable from the cases that are cited to by the appellant, and it would be distinguishable from what your honor is talking about, which is if there is a plain error argument where I need to see the facts, then I need to have that transcript. But if you're just saying something did or did not occur, and the journal entry is clear about that, the court can decide that issue, plain error or any other standard review.
I'm not saying something did or did not occur. I'm saying, was the analysis correct?
Right.
Just can't tell if the analysis is
Right.
correct without a transcript.
I agree, except that that was not presented in this case. I 100% agree with you. I'm just saying that that is not the situation in this case. And the Court of Appeals does not have a duty to say, well, here's what the issue was raised on appeal. Did the analysis occur or not occur? But, you know, it was a better argument, or I'm curious to see, I wonder if that analysis was correct or incorrect. That issue just wasn't presented to the Court of Appeals by the attorney who had the direct appeal or the current attorney who raised the Rule 26B motion. So I apologize if I was not answering your question directly. I think I probably got around to it in a roundabout way, and I apologize for that.
Counsel, the court could have said exactly what was in the journal entry from the bench. I've conducted the analysis and I find, you know, it doesn't apply, or whatever the language was in the, without going through all of the considerations that he or she used. He could have done, or she could have done that analysis in chambers privately, and then came out with the conclusion and put that on, which is, you know, it doesn't fit here, basically, and then we're going to move on, and nobody, you know, nobody objected to that at the time of the sentencing. So just because they said they did an analysis is not proof that that analysis was spoken and incorporated into the record for review by the appellate court.
I absolutely agree. And if that was the issue raised, I would say that they had the ability to set forth a colorable claim, but they did not do that in this case, and that is not what the record shows. If there are no further questions, I would rest on my brief. Thank you, Your Honors.
Thank you. Counsel, you have
Thank you, Your Honor.
Little over a minute.
The Court of Appeals did not say it was relying on the journal entry, as the state is now arguing for the very first time. The Court of Appeals said they needed the transcript to review the merger issue. The journal entry that the state is arguing for the very first time could still be wrong. And the only way to verify that is with the transcripts, which were never created. Further, the Court of Appeals used to routinely grant these 26B motions. I cited to State v. Reed in my brief, and this is now a shift in their policy. I would ask that this court remand to the Court of Appeals for a reopened direct appeal, because when appellate counsel fails to file all transcripts which prohibit any appellate review of a conviction, there's a genuine issue as to the ineffective assistance of counsel. Thank you.
Thank you. Thank you, ladies. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.